Welcome to a video for LLB 345 Internet Law Unit at QUT. In this video, I'll be introducing the case of Crookes against Newton. This Canadian case concerns hyperlinking and asks an important question: whether hyperlinks that connect to allegedly defamatory material can be said to republish that material. But first, let me remind you the Australian law on defamation. In action for defamation, the court must not only consider whether the information can reasonably be said to be defamatory, and whether it in fact refers to the plaintiff, but must also consider the question of publication to a third party. Publication occurs when there is an act that makes defamatory material available to a third party in a comprehensible form, and there is a receipt of the information by a third party in such a way that it is understood. Mr. Newton has a website in British Columbia where he posts articles about free speech and the internet. In the article in question, Mr. Newton hyperlinked to two different websites that contain a defamatory material about Mr. Crookes. Mr. Crookes sued Mr. Newton on the basis that by creating hyperlinks in his article, he was republishing the defamatory material. The trial judge decided that there was no repetition of the defamatory words, therefore there was no publication. Mr. Crookes appealed. The first link, openpolitics.ca, did not take the users straight to an article. It took them to a homepage of a website. Users would have to take further action, for example clicking on other links, to access the articles with defamatory content. The second link, Wayne Crookes, took users directly to the article containing defamatory material. All the users had to do was click on the link. The majority in this case said that the hyperlinks are only references. They communicate that something exists, but they do not communicate the content. They are content neutral. Reference to an article containing defamatory content without repetition of the comment itself was not found to be a publication. Justices McLaughlin and Fish agreed with the majority judgment. However, they introduced a view that if the text that includes the hyperlink constitutes adoption or endorsement of the specific content it links to, then it can amount to publication. But general reference to a website is not enough. Justice Deschamps delivered an individual judgment, and while he agreed with dismissing the appeal, he adopted a slightly different approach. According to Justice Deschamps, to satisfy the first component of publication, the plaintiff must establish that the hyperlinker performed a deliberate act that made defamatory information readily available to a third party in a comprehensible form. An act is deliberate if a plaintiff played more than a passive role in making the information available. Defamatory material is readily available if it can be immediately accessed. There must be no meaningful barrier that would prevent a third party from receiving it. The hyperlink that referred to a homepage did represent a barrier. On the other hand, the link that transferred the user straight to the article with defamatory information did not. The plaintiff satisfied the first component. However, he did not satisfy the second one. He did not prove that the content was brought to the knowledge of a third party. The number of hits in the article during an 18-month period did not constitute sufficient evidence to support Crookes' claim. There was no evidence that someone actually viewed the content or understood it. Law of defamation is, according to Deschamps, maintaining a balance between the protection of reputation and freedom of expression. There should not be any exceptions relating to defamation on the internet. The appeal was dismissed. The importance of the case is that there is no intermediary liability for hyperlinking to defamatory content, which does not constitute republication unless the alleged defamation is endorsed or repeated. Hyperlinks play an important part in the functioning of the internet. It would be impossible to find any information without them. The Canadian case is by no means an authority in Australia. Justice Beach Jones decided not to follow the case in Vischer against MUA. However, the Australian law is more complicated than that. Justin Kiru in Cripps against Baccaras stated that when it comes to hyperlinks, there must be a consideration of a degree of association between the linked articles. The Australian position is further explained in other videos.